All righty, we have updates on a couple of very prominent legal cases in the area. First of all, we all know Sapphire Terry, the girl who was, lost her father and siblings in that fire on Hewlett Street, and was just a national celeb with her, call for Christmas cards, and it just turned into so much more. Anyway, there were a couple of local people you remember who were helping sort through all the donations and stuff, and one of them is a 50-year-old, Laura Lazari. That case looks like it's coming to resolution. She is accused of taking $50 worth of costume jewelry that was meant for Sapphire. If she stays out of trouble, whatever, during a plea agreement for the next 6 months or so, they'll dismiss those charges. The other woman charged in the case, Kimberly Bradford of Rotterdam, took some stuff home, retail gift cards and stuff. That one is still in the legal pipeline, so we don't know the status of that case. That's yet to be resolved. But that first one with the costume jewelry that was meant for Sapphire, looks like that'll be dismissed if everything stays cool for the next 6 months or so. The other one, Kelly, is the case with Noel Alkaramla, the Troy woman. I think she was 21.
Mm-hmm.
Body was found in the suitcase in the river.
Yeah, this is a very bizarre case. I mean, we talked about this for a while. While it was happening, they couldn't find her for a long time. She's 21. She went missing, and they believe that her stepfather was responsible. Someone saw him drag a suitcase down the stairs, and when they took him in on an unrelated parole violation, he said to look for the suitcase and you'll find her. And that's exactly what happened. They found the suitcase in the river, and then they found her body inside. The issue now is trying to connect him to the crime. There was some DNA evidence that was found on her, and there is some DNA records they have because he has a prior conviction, but somehow they're not putting the two together, and I'm not really sure why. We're joined by WGY legal analyst Chas Farcher of Martin Harding and Mazzotti. Good morning.
Good morning, Kelly. Good morning, Chuck.
Hey, Jess.
So can you explain to me why they have a guy who's a convicted felon? He has sort of implicated himself in this case. There is DNA evidence to be had. Why are we even talking about this? Why don't they have the DNA evidence right there on him?
Well, you got to understand, too, you remember, whenever you're asking the defendant to provide DNA evidence, it's a search, so you've got the right against unwarranted search and seizure. So it's never, when you're defending a case or when you're on the defense for a case, it's never about this particular case, but the bigger picture. And I know that's hard to grasp sometimes, but, you wouldn't want another case where maybe the connections weren't quite as clear, where they would just bring in 10 or 12 people and swab everybody for DNA.
So I know that the judges twice, I guess, rejected the prosecution's call to get this DNA swab from the stepfather. Why is that? Because, from Kelly and from our standpoint, it seems like a slam dunk. It seems like the facts are there to justify it.
Because what you're asking for is a search. So what the prosecution has got to put together is probable cause, that the search should go forward. So you need probable cause. And, it seems like maybe that's there because you got this comment about the suitcase, but is it the right suitcase? You have what you have as a circumstantial or kind of tenuous connection there. So, do they have more? I don't know what was in the original application when they asked for the DNA swab that was denied, but, now they've got some witness statements that connect him to this suitcase, maybe his statement. Maybe they didn't have all of that in the initial application. So hopefully they've got all that in this application. Now you get enough to establish probable cause, and then they probably will get it. We'll get the DNA at this point. But what's interesting is that they're doing it pre-indictment or before anybody's been charged. So I got to ask, if they have enough or they have probable cause, why not charge them? I think they're probably trying to solidify the case before they do that. And maybe that's one of the sticking points here.
But I'm a little confused that they already have DNA evidence of his on record from prior cases. Why can't they use that as their sample to compare?
Right. So we got the law in New York that as of 1996, people convicted of certain crimes have to provide DNA. That law has been amended many times. Now it's essentially all felons and misdemeanor convictions that require jail sentences to provide DNA. So he's got prior convictions. His DNA is on record. Why can't they use that? My guess is that one, it's either a very old sample. His other prior conviction was from 1998, and then he's got a sex offender charge in there somewhere. So it may not be as good of a sample as you want. DNA is kind of a fixed science. And two, when you're talking about a murder charge, you probably want a sample that's not so old, not contaminated, maybe not subject to being beat up by a defense attorney. Before you file this charge, once you do that and once you see the jury and jeopardy attaches, you only get one shot at a conviction. DNA evidence isn't airtight. With the circumstantial evidence you have here, you may lose the conviction, and I think you owe it to the family to try and lock that down before you go down that path.
But I mean, just to get the charges here, they wouldn't have enough to charge him. Wouldn't a prior DNA sample? I mean, your DNA doesn't really change over the course of your life, so wouldn't that be enough then to get the evidence together to charge him, and then once he's charged, get a fresh DNA sample?
Well, I would hope so, and that's my question too. And I guess I don't know the answer. I don't know. We don't know everything that the prosecution's doing. But if you've got some, identifiers in the prior DNA sample plus the witness statements and whatever circumstantial evidence you have, you'd hope that would be enough for a probable cause application to have Judge Cerisi to give you that DNA sample, that order to compel the defendant to provide DNA. But again, whatever they put in the initial application, clearly it wasn't because their request was denied. So hopefully that's all in the second application that's supposed to be argued today, but we'll have to see how it goes.
Yeah, we'll see how that second attempt goes. Hey, Chas, that was very illuminating. It answered a lot of questions. Thanks so much for your time. We'll talk to you soon.
Have a great day, Chuck. Have a great day, Kelly.
All right, you too.
Chas Farcher, our legal analyst from Martin, Harding & Mazzotti.